Hey guys, welcome back to Seller Sessions Daily. How are we doing, everyone? I got a little bit of feedback from your microphone, Paul, so I'm just going to mute you for now while I'm doing intros. Yep, I'll start again. Welcome back to Seller Sessions Daily. Today with me, I had Paul Rafelson and Yael Kabili, if I pronounce your name right.
Yes, correctly.
Excellent. So what we're going to be talking about today is trademarks. We're going to be talking about patents and all the usual bullshit and the cat and mouse games that take place on Amazon. And you're going to help these wonderful people out there to get unstuck. And obviously they'll be able to reach you for stuff as well. So welcome to the show, Yael, for the very, very first time. Can you give, Paul, can you give Yael a round of applause, please? His face is frozen there. Okay, yeah, let's go straight into it. So can you give the audience a bit of background on yourself, please?
Yes, thanks for having me, first of all. It's
Pleasure.
amazing what you do every day. So I'm originally a trademark lawyer. In 2015, I started working with Amazon sellers, helping first with IP issues and then with suspensions. Today I have a firm, we're 11. I think that 90% of our work is related somehow to Amazon. And so what we do is, we do trademark registrations, copyrights, patents. We deal with IP suspensions. And I also have a separate company that deals with exits, sale of Amazon accounts, but that's separate, not related to IP.
Yeah, so it keeps you very, very busy. And you're also, is it a mum of three?
A mom of three boys.
A mum of three boys, three terrors. Okay, yeah. Paul, do you want to, I know you've been on the show before, so would you like to give the audience a little bit of background? I know it's been a bit of a rush. You had, you and Jeff, or Jeff had some other emergency project came up. So it's just the three of us today. Is that right? We've lost your voice. Could we unmute you, my friend?
How about?
There we go. Yeah, if you can just, if you just bring your volume down a little bit so you don't hear me in the background, and then we should be good to go.
Okay, I'm gonna eventually get my headphones to work. Sorry, it's so crazy because we have to. It's like I was a teacher this morning. It's because of the virus, like everyone's experiencing with kids. Like we have to teach at home now. So about 5 minutes ago, I was Senor Pablo, the Spanish teacher, which is great because I don't speak any Spanish, but that's just the world we're in right now. But no, happy to be on to talk about this. I'm a lawyer who helps a lot of Amazon sellers with various issues, and trademarks and IP are certainly one of the ones that we have dealt with a lot because it is such a ferocious area of law on Amazon. We pretty much, we do trademark registrations, all I have to say, probably not so much anymore. I don't know about your experience, but with the new program on where Amazon gives you instant brand registry access that we're definitely not a part of and will probably never be invited to be a part of, considering my lawsuit against Amazon on the tax issue.
Well, that will probably put
trademark filing business is kind of slow, but we do deal a lot with infringement. We help a lot of retail arbitrage and wholesalers or diverters with various issues when brands don't like the fact that they're selling their brands on Amazon. We deal with patents, all sorts of just whatever issues, as well as like same thing as we don't really get into the whole brokering of exits, but the legal of M&A is more my background prior to being within an Amazon selling law, which is big corporate law, tax issues, and just corporate structure and setup, stuff like that, making sure you have operating agreements that make sense and actually do what they're intended to do.
Cool. Well, one of the things I just want to kick off the show with, because I can't remember what I wrote, but something I mentioned where I said we have to deal with some of this shit, which it is. There's some problems that we have to deal with on Amazon, and you guys untangle most of that from a legal point of view. But the one thing I want to touch on is a common thing being leveraged, right? So you are a US, UK brand or a brand outside of China, then someone in China thinks it's a really good idea to register your brand as a trademark and then bribe you for like $30,000 because they know you can't get your stock released at the port.
Yeah.
Talk to me about some experience, starting with you, Yael. Talk to me about some experience with that and what are the best things people can do to mitigate that today?
Yeah, I mean, when we first started seeing that, it reminded me of the domain name issues that we had about 10 years ago, where people received an email, hi, I have your domain name. If you want, you can buy it. So it's kind of the same. Some of our clients receive it. Usually starts with an email from a guy from China saying that he registered the trademark. And if you want it, you can buy it, or from a law firm. Very often it's from a Chinese law firm saying, we identified someone who stole your trademark. If you want, you can use us and we will file an opposition together. We're always not sure if the law firm is working with the hijacker. So what we do in those cases, unfortunately, we have to file an opposition or try and buy the trademark from the hijacker. Sometimes, just buying it is the cheapest alternative, even if it's, it's really annoying and unfair. But I think most of the cases, we just file the opposition. We show that the person who kind of hijacked the trademark in China has done it to many other brands. In all the cases I had, they've done it to like 100 other brands. So we showed how, it's a kind of unfair competition. And, in most cases, you actually succeed and obtain the trademark. Sometimes, unfortunately, the seller doesn't notice or didn't receive an email and the trademark gets registered. And in those cases, you need a cancellation or you need to buy the trademark. It is complicated. The best thing, I guess, would be to trademark your brand in China as soon as you're kind of successful, because we've seen that they're targeting mostly brands that sell well on Amazon. They don't target those that have just started. So I guess after a few months on Amazon, if you're selling well, it makes sense to spend like, $600 or $1,000 to register the trademark in China and just, avoid these kind of situations.
Yeah, cool. Yeah. I'm just going to say some hellos. Sorry, I've got a bit of feedback there. I'll do a bit of hellos and then we'll jump back in. So Saibi, hi guys, another great topic. Thanks, Danny, for pulling it together. Top work. Thank you, Sai, for the regular tuning in each day. Silva is saying hello to Alan Gordon. Hello, Alan, as well. Met both of those guys over in Hong Kong. Matt says, easy gang, Oxy, I owe you a phone call. Hello from Prague, smart people out there. Tiffany's back. And who else have we got here saying hello as well? Yeah, so in the feed, we've got Paulina. Hey, Paulina. Eric Payne, how you doing? Ben Valence is back. John Miller. Lazar, hope you are both well. I know you're still on lockdown. Bertrus, I hope you're well. Stephen, nice to see you. Jason, welcome back. Andrew, welcome back. Adam, welcome back as well. Okay, so getting into some questions. I think Paul just popped back there. There was a question here from, and I'm going to try not butcher their name. Is it Ayurveda? Where can we apply for brand registry for UK and Australia? I am from India.
Yeah, so when you apply, I mean, in order to have the brand registry for Amazon, you just need a trademark. So you need a trademark in either country, that sells on Amazon. You can have a trademark in the US or UK or Australia or Mexico, one of those countries. When you have a registration, you can already apply for the brand registry. So you apply for it separately in the UK and in Australia. It's actually quite simple once you have the trademark. You can also, if you've done it, as part of the accelerator, you would be able to obtain the brand registry before, after 2 weeks after you filed the application, more or less.
Cool. Cybe says, how long does the opposition and re-registration of trademark process take in China?
So the opposition can take several months, unfortunately. But, you know, as long as you oppose it, it's not registered. So you don't have any problem. I mean, the minute you file the opposition, it stops the registration and then the process starts. You know, it can take a year, but you don't care because you stop the registration of that particular trademark.
Yeah. So the problem really lies is when someone's got the trademark, then comes to you and say, give me 30 grand. And then you can say no, but then you can't get your stock out. So basically you are leveraged, right? So with that in mind, because they do operate with the upper hand, is there any way of getting that negotiated down? Do they suddenly go, oh, okay, we'll do it for 22? Because they know that if you're turning over $1 million plus a year, you see where I'm coming from. It's like you had literally, you know, when it comes to negotiation's about leverage. What do you have? Are you willing to walk away from the table? But that's an almost impossibility unless you start manufacturing outside of China. Does that make sense? So have you had any success of if someone says they want 30K and we've walked with 10 where you paid like hard-nosed business with them?
Yeah, honestly, they never asked for 30K. They asked for 5, 6K, 7K, not more than that.
Yeah.
So very, you know, sometimes 10K and then they go down. So we've successfully negotiated, you know, down to 4K or 5K. At the end, they just want, you know, the money. So they know that if they'll ask for 30K, nothing will happen. The person, you know, will either file an opposition or a cancellation, and then they'll lose the trademark. They won't get the money. So in most cases, you can sell this for like 5 or 6. The issues that we did have is that we wanted to transfer the money through an escrow because we didn't trust obviously the hijacker, and the hijacker didn't want to use an escrow. So that's a problem we had. And we eventually found a law firm that both parties trusted in China. But that was hard. That was complicated. They never want to use like escrow.com or, you know, one of those companies that you can trust.
Is that also because they don't want to be tracked? Because literally you're bribing you, right? So they don't want a paper trail, and obviously an escrow creates a paper trail. That makes sense. Okay, so Selva, is there a way to get a trademark registered in Canada faster when you have a US trademark? Canada can take 12 months, it seems. Paul?
I think the only alternative to registering in Canada would be to register in another country and then file a Madrid Protocol application. But I think the timeline is going to be about the same because they take pretty long. I mean, maybe not exactly 12, you know. I have to say right now, trademarks in the US are running painfully slow lately. It's really, it's amazing just how slow it's become. I think the UK is still fairly quick.
8 weeks.
Yeah,
8 to 10 weeks.
Right. And I guess as Amazon relaxed, I mean, because unfortunately my partner Jeff is the guy on here, and we've always found that the reliance on a UK trademark for US brand registry is sort of, I mean,
that window's closed. It used to be.
Yeah, it used to be a long time ago. But I hear rumblings that it's been reopened. So I have not seen that.
It does work. It does work. We tried it just 2 weeks ago and it did work. So they kind of stopped it and then it's back. So it kind of works.
If that's back, that was a hack from a year ago, right? They closed
2 years ago. It was
2 years ago.
Yeah,
so what you would do is you go to the UK, you'd register a trademark, secure your brand registry there. You do it in 10 weeks. You'd get your 2 to 3 classes, and then you'd go to the rest of the world. And then you say, I have a UK trademark. And then you'd take that back to the US because obviously it takes 8 months in the US. But I thought they closed that loop. So if they've reopened that, then the quickest way of getting a trademark is to do the UK, right?
Yes,
the quickest way to brand registry, right?
Yeah, the quickest yeah, not trademark. I should have
US trademark, but yeah.
What I meant is in order to get brand registry, you use the UK trademark. Can you touched on the Madrid system? I think it's important for people to understand that, especially for Pan-EU. Can you explain what the Madrid system is, Paul?
The Madrid Protocol, it's basically just like sort of like a single application you can file. I think it's a year from when you originally file your US trademark application. Again, I am not the trademark expert in my practice, so I'm Yeah, you'll have to correct me from time to time. I won't be insulted. But basically the idea is it's kind of a one-stop shop application that allows you to sort of apply for multiple countries at once instead of having to go country to country, which may make sense if you're selling in multiple countries. Now, if you're just selling in one country and you're manufacturing in China, it might be faster just to go get an application, a mainland application in China. But if you've got a couple countries where you want protection, it makes sense to file the Madrid Protocol application, which for a lot of our clients who are selling in multiple Amazon markets, we used to advise. Like I said, we really don't get that many trademark originations anymore because of Accelerator. But that kind of used to be our advice, was that we would recommend a Madrid Protocol application, which would in effect serve your purpose for preventing anyone from hijacking you in China as well. So it serves the same purpose. Because you're getting the registration in China, assuming that's one of your countries.
But I think that the good part about the Madrid Protocol, the best part is that it's cheaper. Instead of having a lawyer in each country, like one in Canada and one in China and one in, India, you just file it once through WIPO, and then they send the application directly to the offices. And so if everything goes smoothly, you don't need a lawyer in each country, and you just pay the official fees, and you pay once. So it usually saves you significant fees if you're going to file in several countries. If you only file in one country, it's usually not worth it, because just to get into the WIPO international system, has a cost. So I usually recommend international applications if you're going to file your trademark in China, India, Australia, 3, 4, 5 other countries. So that saves cost. There's something, by the way, that's important to know, because you touched it with the UK trademark, and I think that it confuses many sellers. It's a common mistake that I see. There's a difference between the brand registry and a trademark. So what happens is that many people register a trademark in the UK, and then they have the brand registry, and then comes a hijacker in the US. So they file a complaint, and the complaint is rejected. Why? Because they don't have a trademark in the US.
Yeah.
So there's a difference. So you'll have the EBC, and you'll have all these advantages in the US as well, but you will not be able to enforce your trademark in other countries if you just trademarked it in the UK. So if you sell on Amazon.com, I always advise to file the trademark in the US, even if it takes a while. Now we have the Accelerator. We're busy with it. It's worth it.
Do you want to, just for those, the uninitiated, do you want to explain how this Accelerator works? I know it's been around for a while now. I take it you're one of the partners in the Accelerator.
One of our associates is a partner, so we file through our associate. So the way it works, you file the application, until recently, when you file the application in the US, it would take 7 to 10 months to get a registration of the trademark if everything goes smoothly. And then only at the end, you would get the brand registry. You can take your trademark and show to Amazon that you have a registered trademark and obtain the brand registry. Now, Amazon is saying if you file the trademark through these offices in our list, then you can have the brand registry after 2 weeks from the filing, which makes a difference for most of the sellers. What we don't know yet is what will happen if people are filing the trademark and then the trademark is rejected or not registered, if they will take you the brand registry that they gave you. That's something that we still don't know, because it hasn't been enough time. But we'll know soon, I guess.
Cool. So Alan says, I've had 3 trademarks issued in the UK and received all my brand registry from Amazon with a total of 12 weeks. Good work there, Alan. Sharon is giving you eyes there. She's obviously showing a lot of support to you there. Hey, Sharon, hope you're well.
Hi, Sharon.
Andrew, I'm going to take him off screen because I don't want to embarrass him, but he's saying here, my competitor doesn't have a trademark in China, but has it in the US. I just filed a trademark registration against him in China, what is the chance that I'll get it through, and can I get caught? May I just say something, Andrew? You tune in every day. Karma, my friend, karma. So what I would say to you is focus on you and your business, and like stuff like that. Leave that to other people. You're better than that. So yeah, do you want to answer his question?
Well, I'll let Paul answer that one.
So I understand the question. They have a trademark in the US.
So my competitor doesn't have a trademark in China, but has one in the US. I just filed a trademark registration against him in China. What is the chance I'll get it through, and can I get caught?
Yes, you can get it through, and you can get caught. I tend to just like I said, I mean, like action like that opens up a whole nother can of worms. And I don't know where you're based, but I mean, if you're based in the US or you have a business in the US, it does potentially open up some potential claims that are outside trademark law, some tortious interference laws. I mean, it's really not a good idea to go about that route. I'll let Yael speak to the legalities of China law, because again, Jeff was supposed to be on this with us and kind of last minute had a ditch. So I by no means ever hold myself out as a trademark person. I know a lot about dealing with the disputes, and I know what I need to know, but the China stuff it's just a whole nother world that I just disassociate with on purpose as much as I possibly can. No, but like I said, I would be very careful about doing things like that, because I first of all, I agree with you on the karma point. That's not the way you win.
But just Andrew, that's not the show you up. That's all love to you, brother. But I would say just focus on do you. Sorry.
Yeah, I agree. By the way, the chances of getting the trademark, are the same as in the US. What examiners are looking for is there a prior application that is similar to yours? Is there a similar name that was there before? You may get it, but everybody sees who the owner is. The owner is on record. People are very often surprised that they file an application and then their name appears on the internet, on Google, when you put the name of the brand. So yeah, you'll get caught probably. And as of the chances, like any trademark. Yeah.
The other thing you got to look at, right, is your ethics level, right? This is what I think people forget. Like when they go against Black Hat and stuff. What you got to remember is you're not playing on a level playing field. You are playing to the level of your ethics. It's how far you willing to go. And if they're willing to go further than you, then you're going to be in trouble, because you'll never win unless you go to their level or beyond that. So that's where you got to be a bit careful on that side of things. We had another question here. Matt says, guys, this is a rookie question. Would it work to register the trademark to your business name brand, or do you register it to a specific product? I'll answer that as well. I'd always say broad. I might use guys as lawyers, but my natural reaction is, if I was running, I don't know, Danny's Sports, trying to go and get sports classes with Danny's Sports may be difficult and get rejected. But if it was Danny's outside gear or something like that, it's going to have less chances of being opposed. And so if you go to product level, also, then you might have to register later, because you might have a product that's opposing that. You might, I don't know, have a dog brand name but sell kids clothing. So it depends on what you're trying to do. Is that you'd always need to make sure, from my point of view as a seller, is to find a broad enough brand name that means something, but not too much to avoid that level of opposition. Is that on the right track?
Well, yeah, and that almost goes to the trademark law itself, and the notion of what is descriptive, right?
Yeah.
If I try to trademark, Paul's blue pens, it's really just a description of what I'm selling. It's not really a brand. Yeah. It's not a mark. Yeah. So, it kind of goes to that you want to be a little bit more innovative. And when you use common words, obviously you have to, in the US, you have to disclaim them, or anywhere. I mean, you have to. So, the more just, even if it's not descriptive, but the more words you put into it, right, the more you kind of open yourself up to competitors basically having a right to basically use some of those same words if they like your product. So the more specific, sort of broad, you just kind of think of it, this is my brand, this is my empire, this is what I want to be known as, the better that I tend to agree that's probably a better.
I'll give you examples. Nike, Adidas. What do they mean? We know what they mean now, but they would have passed through probably a lot easier than most things because they're not down Bebo, the network. Do you remember the social network, MySpace? Maybe that would have been a bit tougher. But having some level of generic or unusual names is going to be a lot easier to see through, wouldn't it? So.
Yeah. I think that, I think he touched two things. One, people often ask me, what do I trademark? Do I trademark the name of my store, of my business, or do I trademark the name of my product? That's a question I get, every day almost. And to get the brand registry, it's important to know, to get the brand registry, you need to trademark the brand, on the product. The name of the store isn't that important on Amazon. You may want to trademark the name of your store, if it's, if you have a website that sells a lot of brands and the name of the store becomes something important, like, Danny's sport goods or something like that. But on Amazon, to get the brand registry, we're talking about the product name, not the store name. Now, the question of generic versus descriptive versus suggestive, that's something that, again, I think that most of the Amazon sellers understand the difference. And I think that, I guess, 90% of the trademarks we get are okay in that sense. But some of them don't know the basic. And the basics are that if you come with a trademark, like, I don't know, toolbox, nobody will give you a trademark for toolbox, because this is something that people will want to use in that field, and it should be, remained in the, the public should be able to use it. If you get it as a trademark, you'll be able to stop others from using it in that industry, and it doesn't make sense, right? It's too generic. But if you do Danny's toolbox or Elephant toolbox, that will pass. That's okay, because you have something unique at the beginning of of your trademark. Or you can play with it instead of toolbox, like try to I don't know, remove a letter or two and make it like suggestive, like toolbow or something like that without the X, something that's suggestive of what you do, but not descriptive of what you do, and that should pass. So that's the difference between a descriptive trademark that will not pass and a suggestive or completely invented trademark like Adidas or something.
Yep, makes sense. Paul, do you want to add anything here before we move from trademarks?
Right. I think the same thing goes with sound-alikes, and don't necessarily fall for, if you spell toolbox, TOLBAWK, they may say that's, again, sound-alikes don't necessarily always work, generally don't. But yeah, I think that just kind of understanding what a trademark is. In theory, legally, what is the point of a trademark from the government's perspective, right? Obviously, the government doesn't care about brand registry, and what Amazon cares about, right? It's about identifying a source, right? So, you're basically, this is something that identifies me, right? This is something that the public will recognize as coming from me and only me. And so that's the point, right? It's about identifying the source of goods. And so while, the cute stuff and things like that are great, but just kind of always keep in mind like what your role is. And that's why the rules are the way they are.
Excellent. Should we move into patents? I know that maybe you guys are not fully versed, or it might not be your total area of comfort. That's fine. But it'd be good to talk about this, because I think now is the time where people are rethinking their research strategy. We've done a show with Kian Gilzara yesterday, and we were discussing building a product from scratch. And I think one of the key components is like, can you get a patent? And what do you need to do in terms of building into your product? And before you go down that road of building something, is there a pattern out there already? So should we go through what you would consider a basic process that someone should be doing before developing a product? i.e. should they be going onto websites and looking at patterns, and where should they find them? So starting with you, yeah, that's okay.
Yeah. So I guess if you're inventing a new product, I think that 80% maybe of the sellers will eventually register a design patent and not a utility patent. So you must know that there are two different patents. One is a regular patent that covers that is quite broad and covers the ID, okay, something that's quite broad and doesn't matter what shape it has, for example, versus the design patent that covers a specific shape. For example, this product is registered as a design patent, right? So even if you put another brand on that product, you would still be infringing Apple's design patent. Oh, you have one too. I hope it's not a fake one.
Yeah, I was going to make a joke, but I just couldn't come up with a good one. But yeah, no, I think it says designed by Apple and Cupertino, right? That must be real, right?
Maybe not. So I think that when we go through this process with Amazon sellers, so if you invented something that's really special and has a new technology, okay, something that has not existed before, you should definitely speak with a patent lawyer and see if you can get a utility patent, because that's something that's broader. A utility patent is much more expensive. It's you're looking at just at 5-10K just to file it, just the beginning of it, and just in one country, it can get very expensive. But this is something that people file mostly when one, they have investors or they have the money, and second, when their entire company is based on that product. So if you invented something that's very unique and has a unique technology, see with a patent attorney if you can register it. If it's just the shape, if you took something that existed, okay, and then you completely change the shape and you have something with a new design, okay, then that would be a design patent, because you didn't invent a new product, but you invented a new design. And design patents are actually very easy to obtain. They're not expensive at all, and you get them faster. Amazon understands design patents, so if you have a registration and somebody copies your design and just puts another brand on it, then you would be able to quite easily enforce it. The problem, I would say, with design patents is that you can work around them. So if you registered this shape, and I would do it like more like a square or something, and nothing rounded, then I worked around your design patent. That's the problem with it.
Cool. I've got a question here from Adam. I'll put it up on the screen, but I'm hiding Paul's head, so let me just pop it back here. So we have a design patent for an item on a product that we've been selling for 18 months in the UK and US. Another company has started selling a very similar item, and they've recently announced that they have a utility patent granted. I've checked the patent. First application was only started 30 months ago, and that is after our item was designed, registered, and selling. Also, to have a utility patent issued in a year was suspicious. After checking, it's not granted, just application published. Guessing that.
Yeah.
So,
right.
What's the question?
Yeah. So I think what he's asking is, in that question, is how can they do what they're doing, right?
Yeah.
And does it have any validation? I think is what he's trying to get to.
So
yeah, go ahead, Paul.
Yeah. So we've seen sort of design patent hijacking before, where people will take a pre-existing design and then try to throw a design patent on it, and then actually try to oust the person who originally designed it. It's kind of funny. And so, patents in basically at their core are, for previously you have to be sort of the originator, right? I mean, you can't take pre-existing stuff and, subsequently patent it, right? That's the so you always have an ability to challenge patents. And one of the biggest, I'd say the easiest ways to get Amazon to back off on a design patent infringement claim is to show prior existence of the product. Hey, this product was being sold for 5 years. Here's evidence of it. I went on Google and here's some evidence of it, in existence 5 years before this patent was issued. So, and it's an obvious clone, So, people do that. I don't really understand why. Maybe they, but they do. And I guess they think they're going to be able to sort of hold you hostage or just, get you suspended, and sort of hijack you in that way. Utility patents, first of all, I mean, again, if the invention already existed, then it's not new or novel. So the fact that they filed an application doesn't necessarily mean that that they necessarily have any rights to anything or will be granted any rights to anything. But you always have to be careful because once that application is filed, you are on notice. So you really have to look at it closely and make sure that, there isn't something there that, it's just, I always get a little bit mindful, but just having an application and just so there's sort of a middle ground too between patent filing a utility patent. And there's this thing called a provisional patent, which you wouldn't necessarily see an application for, but just an FYI, which is sometimes sort of the cheaper middle ground where you can basically create some patent. It basically allows you to say patent pending on your product, which is probably really off topic. So maybe I'll save that for later. Actually, I don't want to go into that now, but so yeah, I mean, you just have to be careful with patents. The other thing I get nervous about design patents is that, if you're wrong, it can be bad, right? Like if you claim you have a design patent and then you knock off somebody else's design patent and it turns out your design patent really wasn't, shouldn't have existed, and you've cost that person a lot of money, you've just opened yourself up to a ton of liability potentially. So I just get nervous around patent enforcement in general. If it's an obvious, we have some cases that are really obvious where, it's infringement, and Amazon can be frustrating because sometimes it's like the cases where it's the most obvious are the ones where they're the most difficult. And the cases where it's like, how the heck is this infringing? And you're like, what, and then they're acting like this is, so it's always that black box of Amazon. But, I'm always nervous about, design patents and like Yael said, you can always work around them. So, and then we've seen cases where people haven't worked around them. What I always advise people to in the design patent arena is I always say, kind of do your own, there's it's not easy to do a knockout search in design patents, but there's some things you can do. For example, just kind of common sense process.
Sorry, Paul, you use that term knockout search. Can you explain what that is? You used an industry term.
It's sort of like a trademark. Well, it's really more of a trade, but just basically like, you have this idea. So now you want to know, is it truly my idea? Can I truly patent it? Or this design? And can I truly, do I actually have a right to this, or did someone beat me to it? Right. Like I have this great idea for, I don't know, for a pillow that's called My Pillow, or I'm trying to think of a product. I'm just really drawing a blank and making an analogy. But so you want to go and you want to find out, okay, has this been invented? Can I sell it? Or, and with design patent, and you're at the, so I sort of the analogy is that you're at the Canton Fair and you see all these products. And because this happens to our clients all the time, they go to the Canton Fair, they see a product that's like, it's amazing. I love this. It's going to sell so well. Within 2 days of actually getting the product into Amazon and selling it, they get knocked out by a big corporation, right? And had they done like a Google image search for that product, like if they'd taken some pictures, they might have seen that, oh, wow, KitchenAid was selling this product or, for the last few years and nobody else. In fact, the only place I can find this product is on KitchenAid's website and Alibaba. That should be a red flag to go check and see whether KitchenAid might have a patent on that product, a design patent. I mean, there's just certain things you should do because we just see that a lot where people go to, places like Canton Fair and they just kind of, oh yeah, we have a patent, and they don't. And what is your recourse at that point? You've just spent $30,000 on product that you can't sell anywhere, and Amazon's going to destroy. So, it's a tough area of law right now, and it's definitely one that's definitely can cause a lot of pain if you're not careful.
Yeah. Would you like to add here?
I think that, the question of patent search is something that, many Amazon sellers are worried about, because as a private label, what do? You look for a good product, right? And then you change it a bit, but not so much. You try to have a unique product, but very often you use a product that was already existing. So, very often unfortunately, they're suspended for infringing a design patent or a patent. And then many sellers ask, like, what do I do? Every time I choose a new product, should I do a patent search? It doesn't make sense, and it costs a lot of money. So, what I always reply is that, first of all, when my clients are suspended for patents, you'll be amazed how quickly they find the patent, once they're suspended. So they become the best searcher on earth once there's a problem. So, you'll be surprised that by a Google search or Google patent search, there's a Google for patent. If you do Google patent, there's a database of patents, which is really, easy to use. And if you want to sell a product that is similar, let's say, to the KitchenAid product, okay, then start by going on, Google patent or even Google, and try to look for KitchenAid patent. You'll be surprised how quickly you'll get to the patent. So, you don't need a patent lawyer for the basic search. Try, spend 1 hour for each product, and, look at, search for your competitors, search for the name and the product, and then you'll see if your competitors have a patent for that particular product. Now, once you found it, it's not always easy to understand the patent and what it's for, but, it's a start, and then you can understand that there's a problem or not. So that's what I always advise my clients. And it's always better, even to use someone on Fiverr to do a patent search for you is better than not doing anything at all. I feel.
Yeah.
Yeah, I agree. It's important. Patent searches are tough because what you're asking the lawyer, and that's why we really don't like to do it. And we'll certainly refer you. We do know some patent lawyers who will do them for, not an insane amount of money, but just the liability we take on. And I don't know if, we take on, just, the risk that we get it wrong, it's too much, like even having a patent lawyer, who we work with, it's just like, it's a tremendous amount of liability that you take on, because if you're wrong and you get sued, and it's, who does that fall under? So it's a really scary area of law, even for me as a non-patent lawyer who knows a lot about patent, deals with the Amazon side of patents. But exactly, they're just, Google Patents is a great resource and a great way to kind of find things and get creative with your searches, and, look for websites that sell the product. It may say patent pending, and maybe it's a good time to get into what does patent pending mean versus having a patent, because I don't know if you've ever seen that. And that's more of a utility patent, sort of thing, where it's basically the right to basically, so like, let's say you have a great idea for a product. You don't know if you're going to spend all the money on filing a patent. You don't necessarily want to spend the money on filing for patent protection, but you want some protection while you kind of shop it around and see what the interest is or test it out. What you can do is file what's called a provisional patent application. And that provisional patent application basically allows you to put patent pending on your product. It doesn't really give you any rights, but it legally allows you to put patent pending on your product. And once you file that provisional application, you have basically a year to file your formal application. But that kind of scares people away. So if you have this good idea, and I guess more for the utility patent side of things, you have this good idea of a product and you're not sure if it can patent it, and you don't want to necessarily spend the money to find out or go through it. There's sort of this middle ground of filing for provisional patent, which would allow you to put on your product packaging patent pending. And as long as it's within that year or until you file that formal application where you can continue to say patent pending, it does certainly scare competitors away and makes them think twice about wanting to get into your product and try to compete against you because you put that out there. Now, I don't know how effective that is these days, given how quickly we can move on Amazon, that, people might just do it anyway, but it offers some level of deterrence, and it's sort of a way. And the other thing to keep in mind is if you have a good idea and you start selling to the public, right, you have a year to file. You can't patent something that you've been selling for 10 years. right? Oh man, I should have patented that. No, you got to do it within the first year of commercial application, right? Like once it's kind of become out there commercially, you have sort of a 1 year window to file your patent application. So, if you really do think you have something that's really unique and cool, it's definitely worth exploring. Those are more fun than when people want to know whether their design patent could, whether they could potentially run afoul of design patent. That's a tough one because you really do have to get creative with your searching and find what's out there. So, but yeah, that's
cool. Well, Matt says, who needs a course when you give this sort of depth? Fire emoji. And Michael said, what's the minimum cost, ballpark, to actually defend yourself in a trademark patent infringement case in the USA, for example?
And that's a very, it depends kind of question. It can cost, it's typically thousands of dollars, right? I mean, defending yourself like somebody's coming after you. I mean, it depends, on how serious the infringement is, who's putting it out there, who's putting out the infringement, how bad, how good is their argument? We've seen some pretty weak cases where we get the cease and desist letter followed by we want to know all your sales, and that I'm not too worried about that. Most of these cases aren't going to be handled on a contingency fee by the other counsel. So, I sort of question whether, a small company is really going to be risking, high litigation. Because once you get into litigation, right, once we get into court, the costs go up exponentially, right? We're talking 6-figure minimum, right? In a lot of these cases. So, that's really where it gets expensive, and that's really not where we're going. But, if you really, it depends, look at even the cases where I would argue there is an infringement, like the Pop Sockets case that's going on right now against that guy in Colorado, where he was just reselling the products. I mean, he's representing himself pro se, but if the brand really wants to get you, if they're really angry, if they're big, it just depends on a number of factors. But, a couple letters back and forth, and, it's not terribly expensive, but, if it gets anywhere beyond that, where you're getting into court, you're getting into discovery, it can get bad. So,
so Andrew's back again here. What he's saying is, hold on, different question. My suppliers, their product designs registered in China, design patent in China. Does the supplier design patent registered in China grant me any kind of safety against someone trying to obtain the same design in the US design patent?
No. So, so the way, first of all, I think, as you said earlier, Paul, for patents, to get a patent, it needs to be a new product. Okay, so you can't patent in the States something that has been published on the internet for like 2-3 years, because the examiners, the first thing they'll do, when they get your application, is to look for that product. So they'll look on Alibaba, they'll look on Amazon to see if it already existed. So if that product has been registered in China, it usually means that it's been existing for a while. So to get that as a patent in the US will be difficult if it's something that's out there. Usually the examiner will see that it was already published. Now, sometimes it happens that the examiner misses that the patent was, or the product already existed and it was already published. So we see many cases where our clients get a suspension for design patent in the US. And when we do a quick search on the internet, we realize that the product has existed for like 5 years before the patent was applied for. So in those cases, you need to cancel the design patent through the USPTO. And then, to cancel it, you just show that it was published several years ago, the exact same product, and then the USPTO will cancel it, and you can show to Amazon that the design patent has been published.
Right. Andrew said, is there an upper limit? It's a good question, actually. Is there an upper limit to the number of brands that you can register in brand registry?
No.
Is there an upper limit? So you can register as many as you want?
That's cool. Not only can you register as many as you want, but Amazon, will permit, through the permission process, will allow you to have separate accounts for each brand, right? As long as you rep that they're unrelated. So there's really no, limit at all.
You can also have them under the same account.
Right. And some
want.
people prefer not to do that, although I don't really kind of understand. I mean, I guess it just makes it easier to sell. So like if you're
accounting, if you've got different business partners within the business, the accounting is a nightmare as it is, let alone trying to mix brands in the same account. And when you sell the brand, you're normally selling the account because you've got the account history there as well, which is using
that separation.
Yeah.
Right.
Did you hear that you're allowed to have several accounts now under the same ownership? It's great. It's great news.
Well, I think it's not the same ownership. You're allowed to have several accounts without going to.
Was that verified? I heard that.
Yeah, see, this has been going on. This is a year old now, but it's new news.
No. It's new. Actually, it's been like 2 weeks. I have it. I can send it to you. It says that. It says that as opposed to a month ago, where if you wanted a second account on Amazon, you had to ask Amazon, and then Amazon asked you to show that there's a good reason for that, and that you have a set. For example, you're selling in 2 separate categories. This is why you don't want them under the same account. Now Amazon says,
I agree with what you're saying. Sorry, I don't want to talk over you. I agree exactly what you're saying, because they officially announced 2 weeks ago as a piece of news, but that's been going on a year. That's been going on since July last year.
What changed 2 weeks ago is that now you don't need them to ask for permission. Now you
that's the point. The permission you didn't have to ask. Yeah. As long as you've got a different, say, limited company and a separate bank account, you could do it. What I'm saying to you, people have been doing that since July last year. I've got proof. Honestly, it's been happening. But Amazon decided, this is a really good time to announce it 2 weeks ago.
Were they doing it without asking for prior permission? Because we've always understood that that Amazon would let you do it, but you always just had to ask first. Like you never wanted to go ahead and do it.
Yeah.
And then now it's saying 2 weeks ago, you don't even need to ask them anymore.
No, that was announced 2 weeks ago, but it's been going on. Honestly,
been going on for a while.
It's been going on since July last year. Yeah.
Got it.
Yeah, it's been official.
Because they're very.
July. Yeah, but they just didn't roll it out. It's a bit like at the moment, that you can send non-essential goods into Amazon, but it doesn't mean they've announced that every single category is open. What they've done is gone in from subcategory to subcategory. So you go in inventory files, and you look in there to see what availability of what products you can send in, because they'll be highlighted or not, which you can send. But Amazon hasn't made an official announcement. It's down to us to have a look to see where they've opened bandwidth. Does that make sense?
Yeah. They now changed the terms of use, and you see in their business agreement now it's official. They actually say that as long as you have a good business reason and your account is in good standing, if both are okay, then you can just go ahead and open a second account under the same entity without asking them, without telling them. I think it's great.
Oh, it's brilliant that they've actually done it. Ben said it's quite an interesting one. We have a grocery account with multiple brands registered under a single account. The same client also has 2 seller accounts for different grocery categories. That's an interesting one because it's in the same category, because one of the arguments could be he's just selling the same type of goods. But if it's a different brand name with different owners, you can justify it, because you might say, I've got 2 grocery brands, but I've got one business partner in one and one in the other. And that will create conflict. And 2, they may want to sell one of the brands and keep one of the brands. So it does make sense. Yeah.
Well, I mean, I think the reason for not allowing multiple accounts is really buy box manipulation, right? That if I had 28 accounts,
what you can't do is what you get suspended for is sharing the same products between the same 2 accounts. You'll get suspended.
Right, exactly. That they'll knock you out for. Right, exactly. That's really what they care about, is they don't, because that's buy box manipulation, right? Because I could just set up 100 accounts selling the same product, and of course, if everyone
gets suspended on one and then go and open it on another, because obviously you get banned from account level.
James asked a good question about sort of, because this just came up, like transferring trademarks within brand registry, and I wish Jeff was here to address that, but because I'm not qualified to speak to that, because I try to avoid looking other than my own Seller Central account, which had 3 sales in the last 7 months, so I'm not really the one to speak. I try to avoid opening the Amazon Seller Central as much as possible. But I think that's a good question, because that is tricky, where you've got the brand, you want to keep the account, you want to transfer rights to the mark to somebody else, and then they want to go and register your mark. So it's a bit of a process where I would assume what I don't know is, I mean, I would presume Amazon would then, well, I guess if you sold the company but retained the account.
You can do that. You can, you can do that. You can definitely sell the brand without the account. The way we do it is, first of all, the trademark is transferred. So we change the ownership. We do an assignment of trademark. And as for the listing, what we do is the buyer kinds of, jumps on the listing like a hijacker at the beginning. And then we take the inventory out of the seller. We take it out, and then we relabel it under the buyer's account, and then we take the goods, back into Amazon under the buyer, and the seller goes out of the listing, and then only the buyer is on the listing. That's the way it's done. Hope it's not too complicated, but it's definitely doable.
But is brand registry officially acknowledging the new co as the owner?
Yeah, okay. We transfer the brand registry as well. That's not,
because that's the part that I don't know. Because I mean, we've seen deals where you can file a trademark, you can file a change of ownership with USPTO, or they're acquiring the shares of the LLC. I know everybody's into asset deals. I think nominal benefit or depend, it's very specific, but you could theoretically acquire the shares of the LLC too, and then there is no change of ownership, so it technically just continues. But how would you get the brand out of one account to the other? I would need Jeff, my partner Jeff, who's the lawyer / Amazon seller, kind of knows that stuff. So.
Yeah, Amazon allows it. It's not too complicated. Amazon approves it and allows it. You just you transfer the brand registry and the listing, and you stay with the account. Although I must say that most of the deals are a transfer of the entire account and not the brand. Because you can just transfer everything with the feedbacks and everything, and then you can just reopen an account after you sold it. So it makes more sense, and it's easier to just transfer the entire account and change the ownership of the account, and then the seller just continues.
Just more reason again maintain separation, which is our big thing, right? It's like
just want to answer Joe's question. Sorry, 1 second. I just want to answer Joe's question. Does one open a second account with the same address, only a different bank account and email address? Let me explain. So I've got 2 accounts, one for Databril, which is for our APIs, etc. So it's separated from the seller account for the Amazon APIs and the MWS. So they're 2 separate accounts. One of them is a partner with my business partner. One is a solo. So we do have the same registered business address for our accountants, but we have a different name, a different bank account. But as I said, we do have the same registered business address, but you would register with different email addresses. You wouldn't register with the same email address. You can obviously become an admin and utilize that same email addresses across, but to reduce confusion, separate email address, separate bank account, separate business name. Is there anything?
I think that also raises a good point about just in general about structuring. What is an ideal structure, and obviously structure. You got to take it with a grain of salt that complexity sort of creates the need for better structuring. But how should your business be structured in the first place if you're contemplating an exit? Are you contemplating selling the portfolio of brands? Are you contemplating selling one brand at a time? So depending on the complexity of the company, I like to see, we typically like to, from a U.S. liability perspective, asset protection perspective, like to see, IP separated from operating companies, things like that. So we have like IP holding companies, and then, one operating LLC for each account or brand that you're running. Just kind of basic stuff like that. There's a lot of benefit to that in the U.S., or a lot of protection potential that goes into that. But that's sort of a question for asset protection time, not really for trademark and IP stuff, but just something to keep in mind that these are your assets, and they you want to keep them safe from creditors, from all sorts of crazy things that can happen, especially in the U.S. Because we love to sue in the U.S. It's like a sport here, so. It's
like dial a claim, like you're in midair and you've already got on speed dial who you're going to, Yeah.
Yeah, exactly. Right, exactly.
James,
number 7. Yeah.
James, different account, 2 companies equal double the tax account, etc. Paperwork, software correct, or is there other options?
No,
James,
no.
No,
The
there
whole
isn't any
idea
other
is to
options,
have
but,
the same,
it's not necessarily double the work, because if you synchronize, like for me in the UK, I've got 3 businesses. If you synchronize the VAT cycles, do them all the same time, and synchronize all your year end at the same time, and you've got a team working on it, yes, there is more work to do, but the maintenance across the 3 businesses can be done in uniform alongside each other. So effectively, let's just say that you've got a bookkeeper and they're working in the Philippines, you can split their time across the different businesses. So you're right, you do the tax twice, or I do it 3 times. I've got 3 lots of VAT and stuff. But once you put it all and compress it together and have SOPs, it's not as difficult as you think it is.
But also, just to add, just to clarify, now under Amazon's new rule, you're actually allowed to open a separate, a second account under the same entity. So you wouldn't need to open.
I didn't know.
Yeah,
that's one thing I didn't know. So that's new.
So you wouldn't need to open a separate company with double the tax. The idea about the new rule is that you can open a second account under the same name, as long as you have a good reason for opening a second account. For example, you're selling another brand completely different, or you're selling another category. And so you can actually open a second account without asking under the same company.
Great.
Right. I mean, and that's typical. We see brand managers who run an LLC, like that's their businesses, and sort of running the Amazon accounts will have just sort of one portfolio under their, umbrella, Amazon account management company. Like we'll see those kind of profiles. I'm just saying, a separate issue though, whether having separate LLCs makes sense from a legal perspective, it's totally different. But from, is it efficient? I mean, from a paperwork perspective, definitely not as efficient. From a federal U.S. tax perspective, it shouldn't make any difference. It is more work because you've got more now you're separating your counting, but eventually, for the most part, at the federal level, and varies at the state level a little bit, that all consolidates anyway. And so at the end of the day, you're no worse off. It's just, a little bit more paperwork from that front. Other thing, I guess, to raise, I know we're running on to an hour, is copyright. And it's the overlooked area of law that I think people need to start spending some more time considering, because it's a good area of law that I think gives people more protection. And people should think about products, because I'll give you an example of something that I've seen, in the supplement space. Supplement people are, we sell these products and the labels are kind of generic looking. And so my brand might be, Paul's Vitamin C and have an orange stripe, and it might be an Amazon's Choice or a popular product. And then in comes Bob, and Bob says, I'm going to start selling Bob's Vitamin C and put the same orange stripe. And what happens is they're kind of manipulating the visual results so that I, as a customer, may not even notice that where it says Paul before, it actually says Bob. I just see the orange stripe. I see, okay, that looks like the product I want. And it's also $10 cheaper. So I just assume that's just a different seller, a different, offer. And we're seeing a lot of manipulation and people trying to rip off generic looking packaging, generic looking things. So, copyright is a great way to add some distinction to your product through artwork, but you got to be, it's got to be careful. I mean, it's got to be meaningful artwork. And something people should look into, like if you're designing a stuffed animal therapy dog that's kind of unique, make sure it looks unique. Don't make it look like every other stuffed animal dog on the planet, and create some copyright protection for yourself. Copyright's also a great way to take out, if you have a good copyright. Again, like anything, you don't want to start just doing things willy-nilly, because you can be liable for damaging somebody else's business. So you better make sure you have a good cause before you start taking people out for things like counterfeit or infringement. But, if you start putting a little bit more thought into how your products look or how your labels look, and how, because the visual things that people see when they look at your product online and think, okay, what can I do to prevent somebody from creating something that looks like my packaging or looks like my product listing? Copyright is a great way to do that. And there's the Digital Millennium Copyright Act too, which is the fastest way to take somebody down. But you want to have a copyright registered if you do that, because they can theoretically get back up. and you may not be with a remedy unless you have a copyright, and then you have to file for an express registration. But that's a whole nother day. But I just want to throw out there that copyright is an often overlooked area of protection that in some ways is better.
Well, that could be a part 2 with the three of us.
Yeah, there's a lot to say about copyright. Yeah. If I can just add in, 10 seconds.
I'll give you the final words there. Yeah.
All right. So about copyrights, there's something, that's a common mistake. So copyrights protects photos and graphic designs and text. And one of the mistakes we see very often is that people copy the graphic design of another seller. For example, you're selling disposable plates, okay? And then you copy the exact same graphic design of someone else. You didn't copy, you just bought it from your supplier, right? You just bought whatever is there. But if your supplier copied the same graphic design, your competitor will be able to suspend you within a second, even without a registration, because graphic designs are protected just by inventing them. If I draw something, if I draw, I don't know, a dog, and you copy that specific dog and you put it on your product, I will be able to suspend you just by showing that I have it on my website. No registration, nothing, just showing I had it on your website, I can suspend your product. So be careful with graphic designs. That's something, as opposed to a shape of a product that needs patent and you do a search. With graphic designs, you don't need a registration. So just do not copy a graphic design. Just take your own designer and design, a dog, but looks completely different, and put it on the disposable plate, and that will be perfect. And you'll have your own copyright, right? You'll be a copyright owner because you have your own design. So that's a common mistake.
See how scary that was? Wouldn't that be powerful if you just flipped that around and had the power? Versus, wouldn't you like to be the person who made the design as opposed to the person who's like, oh shit, That's what I'm saying. Copyright is a very powerful area that we should definitely.
Let's do that into we can roll it into a new show with other elements. I'm gonna, before I say goodbyes, I just want to round up the rest of the week, and then we'll get people to let them know how they can reach out to you. So tomorrow, which is Wednesday, I'm losing day of the week. Round up Wednesday, what's happening on Amazon this week? Kevin King, who else is joining me? Lee Rand's joining me, Norm Ferrer, and someone else I think is joining me. His name will come back to me in a moment. Then Thursday, we're going to be doing Shopify off Amazon at scale. So there'll be a panel there. Then on Friday, Kevin King will join us for leveraging cash, helping you out at the moment, some of the ideas that you can do to stretch it a little bit further. I know we've kind of covered cash flow before, but Kevin's a wizard at this stuff. So there's certain things that we haven't covered that I want to make sure we get in. Then Saturday the 18th, we've got part 5 of Women of Amazon. Again, so that's one of our weekly features. And on Sunday, I'm really looking forward to this one. This is our Mindset Sunday, and it's going to be on mental health. And there's a lot of stuff we want to cover there, because I know a lot of people have been on lockdown. I've been speaking to a lot of people who's been calling me, not just related to Amazon, and it can be tough out there for people. I mean, there's domestic violence has gone up in the UK by 120%. We joke about there's probably going to be more babies come in December, but there's also going to be more divorces as well. So I think with the virus, it's compressed things. I think people's mental health is very important. So I'm going to wrap on that. We'll be back here at 4:00 tomorrow. But Yael, how do people reach out to you?
You can send me, a message through Facebook, or, go to our website. Just Google Yael Kabili. You'll get to our website and my personal email.
Yes. Excellent. And Paul?
Just email Paul at ecomattorneys.com, Paul at sellerbasics.com, or my Facebook group, Amazon Sellers, Tax and Law, something like that. I should know my own group, but it's a fun group. James can vouch for it. I don't even know if James knew, but we're a fun group, and we try to be informative. So about legal stuff. So
cool, guys. Thank you for joining us. Guys, thank you for joining us, and everyone who's in the groups out there as well who shared the video. Thank you very much for doing that. Again, I'll be back here 4 p.m. as always, 7 days a week whilst on lockdown. Take care, stay home, and much love, and I'll see you tomorrow.
Thank you.